Maybe please, Your Lordship, I beg to mention item number 2. Your Lordship, I pray for 2 weeks' time.
Item. You're for petitioner.
Yes, Your Lordship.
Lordship, it is
2 and 8, Your Lordship.
Your Lordship, similar prayer for item number 8.
These are connected, Your Lordship.
Lordship, in 8, oral hearing is left out, but in 2, oral hearing is already over and it's fixed for written argument. We have filed our written argument.
But I think these are new counsel, isn't it?
Yes, Your Lordship.
Yes, Lordship.
So they may not be. They may have a different view of their brief. We still have to. Who's your senior colleague?
Samantha. He's on leave.
On premium by the petitioner. This is matter up to 2 weeks.
Obliged, Lordship.
Please ensure next time, if anybody should, if not Mr. Mahanta, anyone should come and get this matter, heard. Otherwise, 2017 matter, we cannot keep it pending for long.
Okay, Lordship.
Obliged, Lordship.
Please, Your Lordship, I beg to mention item number 4.
Item number?
4. Your Lordship, I pray this matter comes up after 2 weeks.
No objection, Your Lordship.
This is a similar matter. Is it pending before the DP? And here? What was the matter here?
It is with regard to the selection of the private respondents, one who has been selected to be the proprietor of the warehouse matter. That is good in short manner.
On premium by petitioner, this is matter up to 2 weeks.
I do oblige, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 5. I pray for 3 weeks' time, Your Lordship. Conducting counsel is on leave, Your Lordship.
Please, Your Lordship. Your Lordship, I put a private respondent in this case.
Any objection? Any objection?
No, Your Lordship. Just to reflect.
On premium by petitioner? Not objected to by respondents. This is matter up to 3 weeks.
Deeply obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention item 6. Lordship, I pray for 2 weeks accommodation, Your Lordship, in this matter.
No objection. No objection.
On premium by the petitioner. This is matter up to 3 weeks.
Please, Your Lordship, I beg to make a mention of item number 9. I pray if the matter can come up after 2 weeks, my lord. I see the consent of the opposite party.
No.
What is your submission here?
I pray if the matter can come up after 2 weeks, my lord.
What is this matter about?
This is an application for quashing of the FIR, Your Lordship.
Also, madam.
Question of FIR.
Yes, Your Lordship.
What are the offences?
Offences is 3A and 4, Your Lordship. My case is that no offence. Yes, Your Lordship.
Okay, we'll look at this. So how long?
2 weeks, my lord.
2 weeks. On prayer made by the state respondent, not objected to by petitioner. Matter is adjourned. This is same after 3 weeks.
Highly
obliged.
From supplementary clauses, item number 1.
colleague, she went to bring the file from chamber. By mistake, we have missed the supplementary cause list.
What is required?
Lordship, we have filed a petition for vacating the order dated wherein we have been struck off, and for the substitution petition, Lordship.
So the respondents are here.
Lordship.
Mr. Paul, you appearing here?
My lords,
We accepted
Lordship,
notice. We have
lords,
accepted
in
notice.
the first place, this application is not maintainable. I'll take your lordships to the prayer. Your lordships may kindly have a look at the prayer at page 4.
Yes.
Well, lords, in the premises aforesaid, it is most humbly prayed that your lordships may be pleased to admit this petition and may pleased to vacate the order dated 25/7/2023 to enable the applicant to enter into the case of the legal or so-and-so. Unless the petitioner is a person, my lords, a party to the proceedings, there is no application for modification, vacation that's permissible. That's number one. Number two, my lords, there is no prayer for substitution. Here, my lords, the question of substitution also will not, my lords, appear because your lordships petitioner, the respondent number one is admittedly deceased. If at all, my lords, they had to make an application seeking impleadment and make out a case for impleadment before your lordships.
Yeah, that is. I think that is what we have.
Your lordships have indicated that, my
observed
lords.
in the last time around when this matter
Well,
was
it's-
heard.
Where's the question of vacating? There is no question of vacating in your order passed by this honorable court. And somebody who is not a party cannot maintain an application seeking vacation.
Yes, first you have to get yourself impleted. You have not filed any application, or rather, you have not made any specific prayer, as Mr. Paul said.
The other problem is, my lords, that they have given out a chart of at least about 13 people who are supposed to be the my lords, heirs of the so-called respondent number one.
Notice has to go to all of them.
And the application is maintained by one person.
Lordship, we
He
have
does not say he's been authorized by 3 people. They say that some power of attorney was now executed. Now we don't know who's executed the power of attorney. A bold statement made by somebody at some point of time saying that I am related to so and so by so and so.
Lordship, we have enclosed the power of attorney. Lordship, and the annexures are there. Lordship, we have enclosed the power of attorney and entrusted to the applicant herein. Lordship, yes, I may be allowed to rectify the prayer, Lordship, stating that impleadment. Yes, I admit that I have missed out the prayer stating that petition applicant's name may be impleaded as a respondent in this case. I have.
There's no question of millets allowing modification of the prayer because they'll have to be independent applications.
You withdraw this petition and file a fresh one.
Lordship.
Miss People's Charging and Counsel appearing for the applicant who has submitted that the applicant may be allowed to, the petitioner and the applicant may be allowed to withdraw this petition with liberty to file a fresh one. On permit, the seal is allowed. Petition is dismissed as withdrawn with liberty sought for allowed.
Obliged.
From daily list, item number 1.
Malad, the petitioner is supposed to prepare the paper book, Malad. They have not done so till now.
Lordship, we have just received the copies. I'm praying for 3-week times for preparation of the paper book.
And counsel for the appellant has submitted that the paper book could not have not yet been able to be prepared and has sought for some more time in this regard. As prayed for, 3 weeks time is allowed. matter to be listed thereafter.
Item number 3.
Lordship, I appear for the third respondent. Before my learned senior starts, my lord, I would like to draw your lordship's attention to Miss Case 117 of 2022, filed by me. Miss Case 117, my lord.
117?
It's there in the list today itself. No, no.
Yes, Mr. Depp, what is this?
My lord, here, my lord, we had, if lordship is pleased to come to page 20 of this application, I was praying for a clarification or modification of the impugn order. This is essentially a Nokma dispute, my lord. I am the Nokmas of the Aking, and they are claiming that they have an Aking within my Aking. So that is the merit, my lord. Here, the lordship will see the cause title at page 20.
I've not seen that long bike.
Page 20, my lord, is the order MCWPC number 74 of 2021. Yes. So this order was passed in that case, filed by my learned senior, my lord, asking for a direction not to allow the cultivation in the Aking. So in any event, my lord, lordship will see what has been submitted. Mr. P.T. Sangma, learned counsel for the petitioner applicants today, has made a special mention of this misapplication and has submitted that during the pendency of the writ petition before this honorable court, opposite party, that is the private respondents, entering into the portion of the Aking which is under the possession and control of the petitioner applicants and is causing damage to the plantations and other crops of the petitioners. Though the matter is still pending adjudication, it is directed that the parties are to restrain from causing any damage in any manner to the plantation crops or other vegetation, as this will bring nothing good to the parties involved. List this matter on 23/6/2022. So this miscase also has not yet been disposed of, my lord.
I'm sorry to interrupt because this is long back, because I'm not mistaken, because this miscase has been already been disposed of.
No, it's there in the list. How
now
it
it is already for final hearing.
No.
It can be.
If I can just submit.
Let him supply the copy of the miscase.
Let him finish his submission. We'll see.
Yes, Lordship, because I don't have even the copy of this one, Lordship.
If I can just finish, my lord. I was filed this in the month of July 2022. Now he's saying he doesn't have a copy. If I can just finish, my lord. I am not praying for anything. I am just seeking for a clarification of that order. Why, my lord? Lordship will kindly come back to my misapplication. Here, my lord, lordship will kindly see paragraph 6, my lord, at page 8. Lordship will see the subparagraph of paragraph 6 at page 8.
Yes.
It is to point out herein that on 16/3/2022, the applicant Nokma, that is me, my lord, and others had lodged an FIR before the Superintendent Police so-and-so, whereby complaining against the petitioners and his supporters who had come to the agricultural field and destroyed the trees, agricultural produce, so-and-so, my lord. So we have lodged an FIR also, that is there annexure 2. Thereafter, my lord, lordship will see para 7. Yes. Initially, we had filed a miscase that was registered as 109 of 2022. And I had prayed for a similar direction, my lord, to allow the applicant and his family members, who was the Nokma, to cultivate in their portion of the Aking, not what they are claiming, which is under their possession. Now, my lord, by an order of 23rd of June 2022, I have reproduced the order at page 10, my lord.
Yes.
Lordship will see, this was the order passed in miscase 109. By in the instant misapplication, respondent number 6 has submitted that in view of the order dated so-and-so, the respondent 6 is being prevented from attending to their own plantation and crops by the officers of the Jengjal police station. His prayers, therefore, directions be passed. It is noted that neither the state is a party nor respondent 6 has filed an affidavit in the main case. Apart from the FIR, there is nothing to show that they had approached the authorities with a copy of the order of this court for correct interpretation. In view of the matter, in this case is disposed of, leaving the applicants to approach the authorities to clarify the matter. Thereafter, lordship will see at paragraph 9, at paragraph 8, my lord, I have personally gone to the officer in charge of Jengjal and tried to clarify it, but he has refused, my lord. And then in paragraph 9, having no other alternative, I have sent a legal notice also. In this, in a clarificatory manner, my lord. Lordship will kindly come to page 29 of this application.
Yes.
Lordship will see below paragraph 7, this is my legal notice, my lord. I am therefore instructed by my client to request your good office, which I hereby do, to immediately allow my client, his family members and other clan members, workers and cultivators to carry out their cultivation and harvest their crops, vegetables, plantations, etc. And also to direct the other police personnel of your good office not to stop my client, his family members, clan members, workers and cultivators from entering into the village. So and so, my lord. So we were concerned with cultivation in our portion of the Aking, because I am the Nokma, my lord. The entire Aking is under my possession. They are only claiming a portion of that. So I am not aggrieved with that part. So hence, my lord, we have again filed the, but still, my lord, the position remained the same despite the receipt of the legal notice. And hence, my lord, we have filed this miss case, which is still pending. And lordship will kindly see the order in this miss case passed on 25th of August 2022. 25th August 2022.
Where is that?
In the miss case itself, my lord.
Page?
No, in the order sheet, my lord. I am referring to the orders passed by this court. 25/8/2022.
Yes.
Lordship will see there was a observation that an attempt would be made to dispose my misapplication, my lord. So, but till now, now again in between we had not pressed it because the cultivation season had gone during the winters. But now again, my lord, the June season and all is coming. So I am only praying for a clarification of the order passed by this court. In the effect, my lord, that whatever he is claiming is under his possession, that is already in the record. He is claiming an area of about 59 bigots. That is the
not 59, 77.
77. Be it, my lord. So be it. Yeah. The entire remaining of the Aking is under my possession, and because of the probably the misinterpretation, or sometimes the police are also scared, my lord, because the order is there, that I am only seeking for a clarification that during the pendency of the matter, I may be allowed to cultivate in my Aking land, which is under my possession, and I will not touch their area which they are claiming.
Lordship, that is a submission made by my learned friend is not correct.
Is this a dispute about possession?
Yes.
It's a dispute. It's a Nokma dispute. I am the Aking Nokma, my lord. He has not made me a party. He has implemented the Mahari. That is another part. Now, the order, he has come up with a misapplication saying that me and my supporters are destroying the entire plantations in the Aking. It is my Aking, my lord.
No.
And the order was passed in a way that, my lord, that the parties are to refrain from causing any damage to the plantations and crops. Now, as a result of this omnibus order, my lord, the area which is not under dispute, where plantations are being grown by me, is also not being allowed to be cultivated because of this order. So I am praying for that clarification only.
No, Lordship, what happened? We also filed, there is a miscase petition counter. Even first, we are the one who filed a miscase, and another miscase filed by them, claiming counter claiming, because the first miscase was filed in the miscase 74 of 2021, where the petitioner has filed. Even in that petition, in Annexure 1, Annexure 2, we have seen that this respondent, they have destroyed our veterinary and garden, because we have even to substantiate our allegation, we have even enclosed those photos, those destroyed by the client of the this one. It is there because it from.
You're referring to which?
Yes, it is a miscase 74 of 2021.
If I may pray, my lord, if your lordships are hearing the matter finally, then I'll not insist on the miscase. It may be disposed. The entire matter may be heard and disposed of finally.
Yes, that's why, because that's why I'm saying that
once the main issue is heard.
Yes, that's what I'm trying to submit, because now it's hearing that automatically those miscase, my miscase and his miscase, it will go.
So if we are hearing the matter
so
today,
now it is a stage for hearing. So that hearing of the miscase is not urgent.
You're appearing for all the respondents
I'm appearing for the private respondent.
I'm for the district order, my lord.
or private respondent?
Now, on the main case also, my lord, before my learned senior starts, I have a few submissions on maintainability of the petition. If your lordship is pleased to take my affidavit, my lord, filed on affidavit of in opposition filed by respondent 3.
Yes.
Lordship, this was filed on 22nd July 2022. Lordship has it. Lordship will kindly see, my lord. Paragraph 5 onwards, if I may just read very quickly, my lord. Paragraph 5 at page 3 of my affidavit, my lord. Before the responding to the statements in the writ petition, the answering respondent begs to state that the petition in the incident case has assailed the order so and so, so and so. So this is what he has assailed, my lord. He has assailed the order passed by the CEM, whereby his appeal has been dismissed. Now, lordship will kindly have the overlay at page 4. Lordship will see the second subparagraph. At present,
Yes.
the registered Nokmas of the said Aking are one Shri so and so and Srimati so and so, who are the descendants of the original Nokmas of the said Aking, namely so and so Mechik Chubogung. Now, this is an admitted position. It is not undisputed, my lord. It is not disputed. However, it is to point out that the answering respondent here, who he has made party, is only a Chara, who is the elder male member of the clan. But the said Shri so and Srimati so and so, the actual registered Nokmas of the Aking are not impleted. And he is challenging, he is claiming for Nokmaship basically. He is trying to carve out a portion within my Aking without impleting me. And he has impleted a third party who is a Chara.
No,
in
lordship.
this matter.
May I interrupt? This
Now,
whatever we have filed before the petition, the party which is we made in the before the those people what my learned friend is raising that issue, they are not a party before the district council. The EM and the CM, this is a copy of the petition in the order also is related. The party which is the party in the EM, in the court of EM and the CM, we have already impleted them. But now we cannot bring the new, we cannot implement in the before this court. This is the appellate court. We are challenging the order of the EM and the CM before this court. And then my learned friend is saying that maybe he is the real Nokma or that is the real Nokma, because that has to be raised before the EM. Because we are coming here only against the order, agreed by the order passed by the EM and the CM. First instance, the case has been filed before the EM and the CM, and where this my learned friend where he is saying they will not make a party. So we are coming only here before because we are only coming against the order of the EM and the CM, whereby even in the petition, neither in the order, they will not make a party. That's why it is not necessary for us to implement at this point of time before this court. If they are raising that issue of regarding the implement of their party, they should have raised that issue before in the court of EM and the CM, not before this court. Now there is nothing wrong in filing before us, because they are not a party neither in the court of EM neither in the court of CEM. So we have make a party only those people and the party who will make a party before in the court of EM in the court of CEM. That is a very clear.
if I can just finish, my lord.
That is the thing.
So this was one submission.
The submission made by my learned friends, my lord. The correct position is this, my lord. In case, what I understand, my lord, if two people are occupying as a Nokma, my lord, male Nokma and female Nokma, subsequently they has been replaced by some other Nokma.
Yes.
Whether now, my lord, this new registered Nokma is supposed to be in the proceeding or not. I disagree with the submission made by Mr. Piti Sama that those two recent appointed Nokmas are not required to be heard. That
Because
may not
now
be
my right will be
just a
affected.
minute, let me
Yes.
submit
Yes.
this. That may not be the correct position, my lord. Now, for example, my lord, this honorable court pass an order, my lord, and I'm not a party to it, my lord. Then that amounts to an ex parte order against me without hearing me. That is not the correct position of law, my lord. The law says that, my lord, the person who will be aggrieved with the order of the court, my lord, has to be heard, and they have to be made as a party. Now, for example, my lord, now my friend is submitting that because they was not the party in the initial stage in the CM and EM court, Now they are not required. That is not a correct position. The correct position will be the people who is recently appointed, my lord, they should also be heard. They should also be get an opportunity.
No, but have you filed a specific
They have not filed.
specific application bringing this on record?
Yes, in my affidavit I have given all
No,
the...
in the affidavit,
Just
if
I
that is
can
the thing,
finish.
they can file an application
Why
to
should I
implead
file?
them.
Why should I
Then
file?
I will not have any objection. There is no problem for us to implead the new party, but as per the procedure, my learned friend also, yes, I agree with what my learned friend was saying, Mr. Day is saying, okay, that may be correct, but if that is the case, what prevent them, the private respondent from filing an application to implead a new party? That has to be bring before the court, before this court. If that is the case, we will not have any objection, we will implead them. Definitely, we will not have any problem to file the application to include as a party to the
If I can
this
submit,
one.
my lord.
If
They can file an application for impleading.
Right. I don't know how Mr. Sangma
Why
is
are you...
submitting. Just listen. How Mr. Sangma is submitting. Now, for example, I have given him an example and an illustration also. Now, if this honorable court pass an order in favor of Mr. P.T. Sangma, and this order is not implemented because the person who will be agree with the order, they are not a party. They don't implement, my lord. Contempt will not lie against of them because they was not a party. Who will be affected with this order? Mr. P.T. Sangma will be morely affected than any other person, my lord. Because district council, my lord, is the authority who decide the matter. We are not supposed to, my lord, go and see who is destroying who's cropped. That is a law and order situation, my lord, which is created by which party I have no instruction to submit, my lord. But for betterment of his case, my lord, he has to make them a party.
Naturally, but that you see, you cannot just present such facts in a counter affidavit.
If I may
It has to be a
just...
specific application.
If I may submit, my lord. I had informed what has happened, my lord, is that when he had filed the initial petition before the EM, and the EM passed an order in his favor. At that point of time, the NOCMA was someone else. It was my predecessors, my lord. Now, what has happened thereafter is that being aggrieved by that order passed by the EM, which was in his favor, he has filed the appeal, and the CM has dismissed his appeal. Now, basically, he wants that EM's order to be revived. That is the basic premise.
No.
If I can just finish.
No,
If I can
no,
just finish.
no.
If I can just finish, sir.
No,
If I
that
can
is
just
not-
finish.
that is not-
Now that is on the other issue. Now in the course of time, the NOCMA who was there at that point of time has passed away, and new NOCMAs have been appointed, duly registered, along with the GT, and the entire the genealogical tree has also been updated, and he is not disputing it.
No,
Now what he is saying is that since these NOCMAs were not the NOCMAs at that point of time, there is no requirement to implead them. Now the thing is, my lord, he is claiming NOCMAship. I am the NOCMA who will get affected in case his claim is answered in his favor. But the fact remains, my lord.
You see, I think we are clear on as far as that aspect of the matter is
Yes.
concerned. Now the only thing is, how do we bring them on record? In which
It is for
by
him
which
because
mode
he is
and
the
by-
master of the brief. He has to file the application.
No. I'm saying, though I'm the petitioner, I have already stated very clearly, we are challenging the order of the EM and the CM.
True.
So that at that point of time, during the pendency of no new NOCMA has been approved or appointed by the GHATC.
But see,
The party remained the same.
Mr. Sama, by the time the matter has reached this court,
Your Lordship.
circumstances have changed.
Yes.
As Mr. D has submitted earlier, if any order is to be passed, even if it is passed in your favor, it has to be enforceable. You cannot enforce it against a party who is a present incumbent and has not been, impleted this proceeding. Simple as that.
Your Lordship.
So there is no.
As per the instruction, I don't know what my learned friend is
There is no-
referring.
see, there is no
There is no new NOCMA appointed as of now. Since from the case case of 2018, where the initial case was started, from the EM and the CM, they were the mega party. They were the NOCMA. There is no new NOCMA.
If there is a confusion, I will take a specific instruction from the district council whether recently any NOCMA has been appointed or not.
I have enclosed the
But,
documents. I have enclosed the documents, my lord.
In the midst of the proceedings, can NOCMA be
No,
changed?
no NOCMA has
No,
been
it can be,
appointed.
my lord.
Yes, because
Yes.
this is
No.
by
By heritage
devolution.
it
Yes,
will
yes.
But I think the title is in dispute, isn't it?
No, not the title. He is basically trying to carve out an aking within my aking without he has no grievance with my nokmaship. He is saying that this is my aking, my lord, and within that aking he has an area of 79.
Anyway, that matter has to be decided by the
EM court. Yes,
Lordship.
EM decided it in his favor. He was
There-
not agree. He
there-
was not satisfied with it. He
There was
filed
a
the appeal.
There was a
appeal was
civil
dismissed.
civil suit before in the High Court of Guwahati High Court
These
at
are
that
all
time.
irrelevant, my lord.
Civil suit.
Lordship,
Now-
it is there. That order had never been challenged. There was an order by the village court, Wabokri village court, where they have decided there was a 77B court that belongs to Jamati Akang. That Jamatar Akang is still, since there was a separate Nokma. Since from the beginning it is in the, I have put it in the record also, it is there. Let me just complete, my lord. Then after that, what happened? What happened? I'm just trying to tell the history of the case.
Let him.
Yes,
No,
I'm trying to tell the history of the case.
You'll get
What,
your turn.
yes,
Why you-
no, then after that, what happened? There was a village court. It is on record also. It is reflected in the order also. The village court, the Wari Bokri village have decided that there was a 77 account without, and against the order of they went to the subordinate court, district council, and then that order was set aside. Then against that order, they went to the Guwahati High Court. There is a civil revision petition. To revision petition, he says that order, whatever order passed by the village court, that is Waribokri, should not be touched, and it remained that means that 77 Bithot were decided by the Waribokri should not be touched. That order is there. Then after some time, your lordship, we said that since they are not disputing, there is a Jamatar Akang. Jamatar Amati is there. We happen the Jamatar Akang existence separately, and there is a Nokma separately. The separate registration of Nokma was there since for many years, and last recorded was a Jogen Sangma and Repolis. It is on the GT, and now we are claiming that since those our predecessors, the Nokma has already expired. Now we want to register the Nokma as a for Jamatar Akang. Maybe because the EM also have allow us, but EM only say that you can be the Nokma of 59 Bithot, not the 77. Since agreed by that becomes, since the order has been by in the way back in 1986 and 1976 by the court of division bench, not division, single bench of the Guwahati High Court. That order, two order was there. I have annexed. That order have never been set aside. Since I said since that order has taken, since the order, whatever the village court has decided, they're saying that they're declaring that 77 Bithot, it has not been touched, and it says remain till now, it has been upheld. So on that ground, we said that since we should be allowed to become the Nokma of 77 Akang. That is our case.
So that is, you see, we are
Yes.
stating, you are stating the facts.
Yes, that is the
Those
facts.
facts has to be proved.
Yes.
So that is
I'll prove it.
that's a
I'll prove it.
different matter.
It is there on record.
But we are not on that now. Now we are only, as has been submitted before this court, we are only on that part whether the Nokmas have been changed or substituted or.
Yes, I also will get the instruction whether they have. My
That
learned
is the
friend is
case,
claiming.
that's-
That is what I was stopping Mr. Sangma, because now he said that there is no new Nokma, and who is the authority who appoint the Nokma or maintain the register of the Nokma? It is the district council, my lord. That is why, my lord, on the first round only I was submitting that we will produce some documents whether there was any Nokma or not appointed. Second thing, my lord, now whether it is 77 bigas or 100 bigas, my lord, this under 226, my lord, this court cannot decide into the factual positions, my lord. Now only, my lord, this court has to appreciate two factors, my lord. One is the procedure laid down in Dora Sama case has been followed or not, my lord. Second thing, the principle of natural justice has been followed or not, my lord.
That is a different
Yes,
aspect
yes.
of that. Will be, the court will take into consideration when the matter is heard.
Yes.
So
let
first,
We
first
will
you get your specific
yes,
instructions.
on that new Nokma appointment.
Yes.
We will.
Or learned counsel for the parties who have respectively submitted that instructions are required to be received in this case. as there was a submission at the bar by Mr. S. Dev Leonard, counsel for respondent. You are for respondent?
My lord, here also there is a confusion because in the main writ petition there are 3 respondents. I am for the 3rd respondent. In this case, I am the respondent number 6.
This is Sagma is my lord capable of this.
Included parties who are not party in the main case and this case. So in the main case, I am respondent 3.
You are respondent 3?
Yes, in the main case.
Respondent number 3, that in due course there has been that in due course the Nokma of the, what is the name of the acting?
Kodegiri.
Gondengiri.
You kindly have page 40 of my affidavit.
Kodegiri.
Gondengiri Akin
Lordship. Let me verify it.
has been replaced by a new Nokma who is now required to be substituted, who is now required to be implemented in these proceedings. On the prayer of the parties to seek such clarification or instruction, matters adjourned. This is seen after
Let it come up on 3rd of April. I will complete the instruction.
3 weeks.
Lordship. Much blessed, Lordship.
If I can pray for a date immediately after the vacation, because otherwise the miscase also is, because now it will come up immediately after vacation.
You say 3rd week we have to? Yes, April.
2nd or 3rd of April. I didn't do it.
3rd of April will be okay only. 3rd of April.
Let it be 3rd of April. I will complete the instruction.
This matter on 30.
Lordship. Much blessed, Lordship.
Item number 7.
Where's Mr. Sin?
Your Lordship will only decide the question of maintainability. Well, Lordship has held that the petition is maintainable.
In this,
merits.
yes, it is. It has been posted in the hearing column, so it will be heard. If the parties are ready, we'll take up the matter.
Your Lordship, the conducting counsel is on legs, but it's not showing in the board, Your Lordship.
Nobody from any state council? Oh, here he comes. Yes, Sin, we're looking everywhere for you.
We can have it after the vacation. I think Mr. Muziga is also occupied with some matter in court number 2 after vacation.
On prayer made by the your additional senior GA or
No, it's here. No, just GA now.
Mr. SN GA, Leonard GA, waiting for the state petitioner. Matter is adjourned. This is him after 3 weeks.
Highly pledged.
Item number 10.
Your Lordship, in this matter, I pray if this matter may come up after vacation, Your Lordship.
Why? We have made it very clear the other day that
My lord.
Yes, Your Lordship.
who's appearing with the petitioner?
I'm appearing on
you-
behalf of the petitioner. Your Lordship.
And you have
respondent number 3.
respondent number
3.
and for 2. Who's for 1?
Lordship, I'm appearing for respondent number 1.
Okay. When do you want it?
After vacation, Your Lordship.
Submission has been made on behalf of the landed TSGI seeking accommodation on ground of his personal difficulty. On the said submission not being objected to by the respondent, matters adjourned. This is after 3 weeks. But this is matter has just been lingering on, mostly because of your insistence not to be heard. If you are a petitioner, you should pursue your case.
I think item number 11 and 10 and 12 will be taken up first, my lord.
11, 10 and 12. Oh, this is 10.
Yes, Your Lordship.
But here,
Yeah, my lord,
11.
item number 11 and item number 14 with regards to the charges.
Yeah.
So the
So
lordships
this
allow these applications automatically, the other applications also will go.
11, 12,
My lord,
13 and 14.
11 and 14. 12 and 13 pertains to my postponement of trial. Now, 11 and 14, my lord, in regards to the charges.
You're aggrieved by the framing of charges.
Yes, my lord, the petitioners.
But I believe the proceedings are still, progressed.
My lord, I'm only on item number 10, 11, 12 and 13.
So you are in 11, 12 and?
No, my lord, 12 and 13. 10, 12 and 13.
So you will be in 11.
Yes, your lordship.
You will be in 11, 12 and 11
Yes,
and
sir.
12.
Yes, sir.
13, 14, and for the petitioner.
10, 14, yeah. So what do we do with these matters then? What is required here? Oh, this is also only for your reply, isn't it?
Yes, Your Lordship.
So we'll hear it after vacation.
My lord.
So, as prayed for by the parties, this is matter after 3 weeks.
Your pleasure, Your lordship.
Thank you.